Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 148 notice. The name of the case is Shri Lakshmi Narayan Agency versus Income Tax Officer, and this case has been reported in 450 ITR at page number 650. The matter has been decided by Orissa High Court and the date of the judgment is 3rd January 2022. In this case, in notice under section 148 was issued to the assessee for the assessment year 11-12, and the reasons which were recorded for issuing the notice under section 148 were the copy and paste of the report of the Deputy Director of Investigation. There was nothing more than that in the reasons. The law point on this is that the assessing officer has to show in the reasons that there is an application of mind by the assessing officer for establishing a nexus between the information with the assessing officer and with the escapement of the income of the assessee. It is not a ritual that you produce the report given by the investigation wing and without establishing that how that information is responsible for the escapement of the income. When the assessment proceedings were going on, the assessee objected the reasons, but even those reasons and the objections for those reasons were not disposed of by a separate order. Only those objections were taken care of in the assessment order. But the procedure is that, according to the celebrated case of Supreme Court, in the case of JKN Driveshafts India Limited, there is a clear mandate that the assessing officer has to dispose of the objections of the assessee in a proper manner. Apart from this, during the assessment proceedings, the assessee has asked a number of the times to give the opportunity of cross-examination of the various persons whose statements have been recorded by the Deputy Director of Investigation Wing and on the basis of which the notice under section 148 has been issued to the assessee or the allegation has been made on the assessee. But during the assessment proceedings, neither the report of the Deputy Director of Investigation was provided to the assessee in spite of several reminders, nor the opportunity of cross-examination was given to the assessee, and at the fag end, the assessment order was passed under section 143 subsection 3 read with section 147. There was two options for the assessee, either to go to the CIT appeal or to go to the writ. So the assessee in this case chooses to go into the writ petition on the basis that the principles of natural justice have been violated and this assessment is not as per law. This assessment is not as per procedures, because the court can intervene directly when there is a breach of the procedures. Procedures are very important to be followed. In this case, the Orissa High Court quashed the whole assessment and said that cross-examination is a vital part, and in spite of various times the assessee has asked for the cross-examination, the department has not provided the cross-examination to the assessee. Even the report of the Deputy Director of Investigation was not given to the assessee. And one important point which in this case was that the objections of the assessee towards the reasons were not disposed of by a separate order, but it was only forming a part of the assessment order. Friends, if we read the whole judgment, we came to know that basically this case was revolving around the importance of cross-examination. But my point is that during the assessment proceedings, we should ask in these type of cases that the opportunity of cross-examination should be provided to the assessee, and we should also mention the points that on which points we need cross-examination. For example, the department alleges that you have given the cash and you have taken accommodation entries. So the points may be asked that to whom I have given the cash, who has come to collect the cash, from where they have collected the cash, which party has introduced me with the entry operator or a number of the questions. So in this case, the assessee got the case and the writ petition was disposed of in favor of the assessee because of the lethargic attitude of the department in not providing the information properly and not following the procedure of as per law. At the end of this video, once again I am repeating the name of the case. The name of the case is Shri Lakshmi Narayan Agency versus Income Tax Officer and others, and this case has been reported in 450 ITR at page number 650. The matter has been decided by Orissa High Court and the date of the judgment is 3rd January 2022. Thank you, friends.